years from the date of filing. And if it is not filed, then your application is deemed to be withdrawn. It is not examined. So, for natural person or startup or small entity or education institute, they have to pay only 1,600 rupees for Form 1. And other than those entities, other than the natural person, that is the big companies or the MNC, they have to pay 8,000 rupees. Then there is no fees for Form 2 up to 30 pages and 10 claims. However, if the pages exceed, if the number of claims exceeds 10, then there is a per page charge, or there is a per claim charge. Form 3 and Form 5 have no fees. For natural persons, startups, and small entities, it is 4,000 for Form 18, and within them, it is 20,000 for Form 18. For more details on this, you can refer to First Schedule of the Patents Rule 2003. Now comes design. Design are the aesthetic aspects of a product. So according to the design law, design relates to the feature of shape, configuration, pattern, or ornamentation applied or applicable to an article. Like we have the Bisleri bottle, we have the different kinds of bottle like Kinley, Bisleri. They have a certain shape, so those shapes are also registered as design. Then the jewelry design, the crockery design, they can also be registered under design. Uh, then other examples are arrangement of buttons and camera on mobile phones, or the arrangement of camera lenses. They are also registered as design. Crockery design, jewelry design. So when a design gets registered, a design number is obtained. Then while making a design application, one has to tell the product onto which that design would be applied. So you need to tell what your design is. You also have to tell the product onto which that design would be applicable. So um, there is the class. Now the product will belong to certain class. Now the uh, classification of the products that is given in the designs rule. So from there you can refer. From there you can refer onto which under which category your product is falling, and you can get the class number. So for this biscuit, the class is 0101. Then the title and the date of registration. So why do we need a design? What is the importance of design? The consumer, it helps consumers to recognize and it. If the product is aesthetically good, then the consumers are attracted towards it. And the design registration prevents duplication of the product or the counterfeiting of the product. Legal proceedings can be initiated against the person who copies the design, a registered design. Then design registration also creates unique selling points and protects the look of the product. Then the design is protected from infringement under the Design Act 2000. So any design which is new and original can obtain a design registration. But the design which has been disclosed to the public by publication or in tangible form or by use or by any other way prior to the date of filing, then such a design cannot be registered. Also, the design should be distinguishable from the known design or the combination of design. It should be distinguishable. Then it must not contain scandalous or obscene matter, must not be detrimental to the security of India, and should not include any trademark or copyright. So a design cannot have any copyright or trademark. Now, certain designs which cannot be registered, signs, emblems, or flags, or mere change in the size of an article, then structures and buildings, layout design of ICs in cartoons, cards, books, calendars. These are the designs which cannot be registered. So you can visit our patent office and file a design application, or you can electronically file at online.ipindia.gov.in/edesign. Now comes trademarks. Suppose you are running a business, so your company will have some name, it will have some brand. Now, if the other person copies your brand name or the trade name onto products or services, then what will happen? You will lose all your customers, you will suffer losses because the brand name or the trade name is cannot be legally protected. However, the trademark can be protected. So you need to register your brand or the trade name under trademark law. And once this gets registered, it becomes a trademarks. So trademarks prevent counterfeiting of products and also identifies and distinguishes source of goods or services of one traders from another. Now, the trademark can be a word, name, logo, or a symbol, or combination of these. The trademark registration is provided initially for 10 years and then it can be renewed indefinitely for 10 years each. These also provide monopoly over a class of goods and services. For example, if you want to have pizza, you will prefer going to Domino's or Pizza Hut rather than some random restaurant. Similarly, if you want to purchase shoes, you will go for big brands such as Reebok, Nike. So why is it so? It is because they have established monopoly over their goods. People are assured of the quality of their products. So importance of trademarks, it allows a business entity to build public goodwill and reputation, assures customers about quality of goods or services. Trademarks are protected from infringement under Trademarks Act and Trademarks Rule. But if the trademark is no longer in use or it is not renewed, then the trademark rights are lost. So some of the examples of trademarks are this Pizza Hut, Domino's, Burger King, Adidas, Reebok, Nike, and Puma, Coca-Cola, Pepsi, Naukri.com, Amazon, Bata, Amul, Nestle, Kellogg's. These all are the famous trademarks. So a good trademark should be distinct, should not be similar to already existing marks, should be honestly adopted or coined, must not be copied from anywhere. So while adopting a new mark, always conduct a search at your level to as to avoid unnecessary litigation. So when you apply for a trademark, you can write TM with your brand, and when your brand gets registered as trademark, then you can write R. Now comes copyrights. Copyrights are the bundle of rights given to the creators of literary, dramatic, musical, and artistic work, and the producers of cinematographic films and sound recordings. Now, the bundle of rights means the creators will get the right to reproduce their work, make copies of their work, then the right to communicate to public, the right to performance, they can perform their work, then right to adaptation means They have a if a creator has written a book, then he has a right to make a movie on it, and these rights they are sellable. That means they can be sold to third party. A creator can sell these rights to this or can license those rights for some time to the third party, and he can obtain royalty from his work. Now a copyright is an automatic right. Means as soon as the work is created, the copyright will come into existence. But if you don't apply for copyright registration, then you cannot prevent unauthorized copying or reproduction. Other person can copy your work and can sell your work. He can make copies of it. So in order to prevent that from happening, you need to apply for copyright. Now authors, painters, sculptors, producers, musicians, they all can get their work copyrighted. This allows the owners to choose the way his her copyrighted works are made available to the public. Now, the copyright cannot protect an idea; it can only protect its its fixed form, its tangible form. So, if there is a movie which is based on some idea, and the other producer or the director wants to makes a movie on the same idea, then that is very well allowed. It is not a copyright infringement. So an idea cannot be protected using copyright. Only the tangible form of it can be protected. Now the subject matter of copyright. Books, poems, then paintings, musical notes, ballets, skits, plays, dramas, songs, movies. These all are the subject matter of copyright. Last is geographical indication. Geographical indications are the signs that are used on the products that have a specific geographical origin or possess qualities or reputation that are due to that of origin. It also states that a particular product belongs to a particular place. So, famous example is that of Darjeeling tea. So, the word Darjeeling is a geographical indication, and Darjeeling tea is a GI tag product. Now, the producers of the Darjeeling tea, they can prevent others from using the word Darjeeling for the tea which is not grown in their tea gardens. Another example is that of Nagpur orange. So, where the Nagpur is the geographical indication, Nagpur orange is GI tag product, and not all orange can be tagged as Nagpur orange. Only the oranges which are growing in Nagpur can be uh, tagged as Nagpur orange. Then these GI, they are primarily given to agricultural, natural, or manufactured handicraft product originating from a definite geographical territory. For example, Kashmir saffron, which is an agricultural product, and Kashmir Pashmina, which is a handicraft product. Now, the importance of geographical indication. Now, usually the GI tag products, they have certain reputation among people. They are generally of good quality, and so they can be sold at higher prices. So GI tag products have can be sold at higher prices. Then the producers of such GI tag products, they uh, they are they are either small enterprises or they come from rural places. So since these products they can be sold at a good price, they are able to compete with the big players in the market, and this promotes fair competition. Then this also leads to the rural development of place. Now the GI protection is provided under geographical indication of goods Act 1999. So who can apply for registration of GI? Any association of persons, producers, organization, and authority which is established by law. they can apply for GI registration. And the people belonging to those producers, those organizations or those associations, only they can use the GI tag on their product and not others. Initial term of registration is 10 years, which can be renewed indefinitely for 10 years each. So some of the famous GI tag products are Darjeeling tea, Makrana marble, Vietnamese safe, Kanjipuram silk, Chandevi fabric, Lucknow Zardozi, Madhubani paintings of Bihar, Ratnagiri or Ponzu. So these are all famous GI tag products. So a quick recap on the validity of IPs. The patents are provided for 10 years of term from the date of the filing. Design registration is given for 10 years and it can be renewed for another 5 years. Then initially, trademark registration is given for 10 years and it can be renewed indefinitely for 10 years each. Similarly, for GI, initially for 10 years and then indefinitely for 10 years each. Copyright copyright registration is available for uh, copyright protection is available for lifetime of a author plus 60 years from his death. So career options in the intellectual property. You can become examiner like me in patent office, or you can also become registrar in copyright and trademark office. Then you can also become patent agent or advisor, sorry, IP advisor or IP lawyer or patent drafting specialist. For further training, you can contact Rajiv Gandhi National Institute of Intellectual Property Management, which is situated at Nagpur, Maharashtra. And you can also visit our website at ipindia.nic.in. Thank you. Any queries? Anyone has anything to ask me?
Yes, ma'am. Sorry, it wasn't audible. There was a...
Any query?
If there are any queries from the participants, kindly raise them here. Miss Shazia Alone, kindly unmute your mic and ask the questions. You have raised the hand.
Okay. Ish R. What do you want to know about patent? somebody asked me to repeat patent, so I just want to know. Okay, what is patent? Patent is a right which is given to an patentee for his invention, and according to this, a person can prevent others from using, making, or selling his or her invention without authorization.
Ma'am, Dr. Said was right. I just want to ask one question. Do patent office provide any assistance for drafting of patents? Because I think that's the most chargeable thing. Because fees is very less, but you need to draft a patent in some technique through some technique. So, do patent office provide any assistance for that?
No, patent provide do not provide any such assistance. But yes, if you are a startup, if you are not an individual but an startup, then there is an SIPP program also initiated under which the startup can get help um, from patent office.
Uh, And ma'am, one more question is there. The earlier TIFAC used to help for drafting of patents. Is it still working TIFAC?
Sorry, can you please repeat your question?
Earlier TIFAC, TIFAC was helping in drafting the patents for inventors. Is it still there?
Well, I'm not aware of this. I'm sorry.
Okay. And one more query is there. Can an inventor file patent himself or he needs an agent for that?
No, inventor can file a patent application on his own. He doesn't require a patent. It is not a mandatory thing.
Yeah. And what about e-signing? Because then he has to get, because at the end of filing a patent, you have to e-sign it.
Okay.
So usually we people don't have e-sign facility available with us because we don't require it actually. It costs around 5,000 rupees or 10,000 rupees to get e-sign. So is it mandatory for him or her to get an e-sign? Because
I,
patent filing is online right now, na?
yes, but it should be. I think it is a mandatory thing. Yes.
Okay, thank you.
Are there any other queries? Kindly go ahead. Shazia Noon.
Hello, ma'am. Am I audible?
Yes.
Yes.
Okay. Thank you very much for such a valuable session. It was quite informative, ma'am. I have one query. Can idea be patented? I mean,
No.
if you have only idea, uh, can that be patented? Because as we are the college teachers, we don't have that much resources available where we can work on the idea actually, where we can develop some machine. If a teacher or a researcher only has an idea, can that be patented?
No, that cannot be patented. Only a product or a process can be patented.
Okay. Thank you.
Yeah, Dr. Shabana.
Yes, Dr. Sadiq Khalid,
Yeah, I
sir.
have a
Kindly
query. I have a
go
query.
ahead.
Thank you, Dr. Manisha, for providing us insights into this IPR. So, one thing I would like to add in your opening slide, you mentioned about types of IPR. I think one of the IPR was missed out in that. That is related to plant varieties and breeders' rights act. So, one thing. So
So that is not an I.
that's
That
a
is
form.
not
That is a form of IPR also.
no, not under Indian patent law. No.
But we have plant breeders varieties and rights act is already there 1970, so that is just an observation. So
I
that
think
is one
that
thing.
is.
And another thing, just
Maybe
I would
I'm.
like to hear from your side is, can you provide us insights into freedom to operate? Because you see, you mentioned, you emphasized that if any person has any invention, so it is better to just keep it sort of secret so that we don't disclose it with any other third person unless and until we just protect our rights also. So you just provide some insights into freedom. Freedom to operate is also very important aspect of intellectual property rights. That is one aspect. And another important thing is about the IPC class. So how we classify these patents as far as different domains are concerned. So anything you would like to add regarding the IPC class?
Uh,
How we categorize them as so far as different domains are concerned?
no, but why do you want to classify your invention? I don't get that thing.
So we should be aware. You see, for library,
Hmm.
we have a classification. When we visit any library, we categorize books as per different classifications also. Patents also we classify. If we have patents which are related to medical field, patents which are related to agriculture, I am asking in that context only.
Okay, okay, yes. Uh, there can be interdisciplinary inventions also. Means they can have uh, some some of the portions from mechanical, maybe some of the portions from electrical, and they can be electrical or communication branch. So that way you can classify it. Like the engineering field, they are classified. Similarly, these inventions they can also be classified. But nowadays, what we are observing is that most of the applications they are of interdisciplinary nature. They are the combinations of various fields. They will have the computer science thing also, a computer program also. They will also have the hardware. Somewhere it is combined with turbine, somewhere with motor. So or interdisciplinary applications are coming in. So that way,
So anything about freedom to operate, how we can operate.
no, sir. I think that is not allowed. If you want to have patent, then that thing is not allowed. You cannot if you have not filed your patent,
You see,
if
this
you have not filed
patent
a
business,
patent
this is
application and if you're operating it, then it comes into public domain. We cannot grant you patent then.
you see, even if inventors or for that matter assignees who have granted patents, right? So when they operate in the market, in the open market, so we have this concept of patent sharks. There are people who are just waiting there to just check whether people are in some sort of litigations we have, infringements and all that.
Hmm.
So the point that I'm just trying to emphasize is that this patent business, this is a very tricky business. We have to be very cautious before actually launching a product into the market, even if we have granted patents, because we have seen that even granted patents they can be invalidated by their competitors also. So that is a word of caution with this patent business also. Even granted patents can be invalidated by their competitors who are operating in the same field. That's very
Sir,
important thing.
Sadiq sir,
Yes, sir.
I would like to add one thing in this. For that, in Indian Patent Act, we have pre-grant and post-grant oppositions. So usually
Exactly.
a normal patentee he does not go for all for the searches, preliminary searches like freedom to operate and all those things. He just files a patent to Indian Patent Office, and Indian Patent Office, I guess they classify the patents through IPC classification, and then it goes to different controllers. Maybe Madam can add to that. And for this thing, uh, freedom to operate. I guess I don't think patent office do anything about that thing. They just grant you the patent, and if there is any opposition, that will come in pre-grant or post-grant opposition. Maybe ma'am can add some more thing to it.
No,
You
what
see,
you
OS
said,
sir, just a minute, madam. Just I would like to add. So, if we are getting a patent granted here in India, you mentioned about the territorial rights. There is nothing sort of concept of we get a patent all over the world. We have rights. So, when we have to go for
Yes,
the sanctioning of the rights, we have to go for individual jurisdictions also.
yes,
Okay.
yes, yes.
So, most of the people they prefer to go through WIPO, because
Yeah,
in WIPO we have this concept of International Searching Authority,
yeah,
ISA. So
yes,
it becomes a person becomes really confident when he or she gets it searched from some other third agency order, in order to be very sure that nothing same is being already there in the market. So I am just coming up with this word of caution that it is good that we have to get patents granted and all that. We have to file for patents also. But at the same time, this is a very tricky business because there have been many multinational companies which have ended up, they have been closed because their
Yes.
inventions, they landed up in courts, and the decision
Yes.
that came from the court was they had to pay huge compensation because they
Yes.
were infringing on the actual invention.
Yeah. Yeah. Actually, the best way to go for patent is WIPO, I guess. You
No,
should
it's
file
not.
it through PCT.
I would like to correct you.
If you want to validate in different countries. Although IPO, yeah, PCT doesn't grant you patent, but it gives you a good opinion about your patent, how good your invention is, how strong your invention is, because International Searching Authority gives you the best search, I guess. Please, ma'am.
Well, sir, but prerequisite is you have to file first in the home country. That is a
Yeah, yeah.
prerequisite.
In India, we have to. In India, we have to.
Yeah. Yes, yes, exactly.
Or you have to get a permission from IPO, I guess.
No, no, no. Look, you have two ways. If you want to file in other countries, there are two ways. First is the convention route. The other one is the PCT route, and not WIPO. It is not WIPO. It is PCT route.
PCT, Patent
Through
Cooperation Treaty,
Yeah.
exactly.
PCT. So if you want to directly file through PCT route, then the patent office will act as receiving office. You will file your patent application to India as receiving office. Then we will transmit your application to IB, International Bureau, and then all that process will start, and then ISA and all that thing. Okay, so you have to first approach our office only, and it will act as a receiving office, and through
And
that,
also, I would like to add, we have jurisdictions also in India. So
yes,
Yeah.
here in JNK, we have to file at Delhi office.
At Delhi only, yes.
Likewise, in South we have Chennai, we have in Mumbai, and in
Yes,
South
yes.
we have
We have 4
Kolkata.
jurisdictions, I guess.
So we have 4 jurisdictions here.
Okay, thank you. It was a healthy discussion. Thank you. Thanks a lot.
Thank you, Manisha. Thank you so much.
Is there any other question? Well, I think no. So, thank you so much to our esteemed speaker, Ms. Manisha Lakhera, for deliberating upon who can apply for the patents, how to file a patent application, the forms required for patent filing, and acquainting us about which designs can be filed and which cannot be, about the copyrights and all other things related to IPR. Thank you so much. So before concluding, it's my duty to formally thank all of you on behalf of the CIED SP College and on my own behalf. I'm thankful to our worthy principal, Professor Dr. Khurshid Ahmed Khan, our esteemed speaker, Ms. Manisha Lakhera, Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, all the participants, members of CIED SP College and Department of IT for their support in conducting this workshop. Thank you so much, all of you. Goodbye.
thank you.
Thank you, ma'am. Thank you, ma'am. Thank you, Shabana, ma'am.